Hello and welcome to this week's episode of For the Love of Chiropractic. I'm your host, Dr. Robert Freeman. And on this week's episode, we have a very special guest. My guest this week is an accomplished litigator with more than 3 decades of experience in insurance coverage, malpractice, and personal injury law. He's based in Annapolis, Maryland, and he represents individuals and businesses, including the majority of chiropractors in the state of Maryland and their insurers. He also maintains an active practice representing other medical professionals in licensure disputes. His understanding of the law from the perspective of both plaintiffs and defendants makes him one of the most sought-after attorneys in the Baltimore-Washington region. I hope you enjoy my conversation with Mr. Paul Weber of the law firm Hyatt and Weber. Welcome to Season 3 of For the Love of Chiropractic. Season 1 has 60 episodes of practice management tips to help you build the best practice possible. Season 2, 3 keys of my success, 50 interviews with the most successful chiropractors from around the world. Season 3, resources for your success. So let's listen up and learn how to build a great business. I had the opportunity to catch up with Mr. Paul Weber by phone. Paul, are you there?
Doctor, how are you today?
I'm doing just great. And Paul, please feel free to call me Robert.
All right, Robert.
So I know how busy you are, and thank you so much for taking and making the time to record this interview with me today. So in the interview and in previous conversations, you mentioned that you've been practicing for over 30 years. So I've got to ask you, how did you get into healthcare law and licensing disputes?
Well, I was working for an insurance defense firm in Baltimore, and we started doing work for a company known as NCMIC, which had started writing insurance in Maryland. And really, that was my first medical malpractice insurance company that I did work for. So there's a special place in my heart for NCMIC and chiropractors, to be perfectly honest. And it's been doing it ever since for about 35 years now.
Well, and having served on the Maryland State Licensing Board myself, I know that you have represented a significant number of chiropractors here in the state, and I can say firsthand they have had phenomenal representation when represented by you.
Well, you're very kind, and there's a mutual respect there because of the fact that you did a great deal of service for the Maryland board and really turned it into a professional board.
Well, thank you very much. So, all right, I want to dig into some of the things that I was hoping we could talk about. So, having so many years of experience behind you, and hopefully many more ahead of you, obviously, what are some of the most common issues, that chiropractors face, specifically when it comes to licensing and or from a malpractice standpoint? Maybe that's 2 questions. Let's take it one piece at a time.
Well, as any chiropractor knows, it's a hands-on profession. That's by definition and by practice. And people come to a chiropractor with, obvious physical problems. And to try to address those problems, obviously, chiropractors place their hands on the patient, and they try to provide the best treatment that is possible. However, if a problem gets worse, obviously the chiropractor's in the mix at that point.
Sure.
And the allegations are always made that, you are the cause of all the problems, and the problems that they came into the office with, conveniently leaves their memory. So, whether it's a disc injury or a compression fracture or a dissected artery, you suddenly, because you put hands on the patient, you are the cause. And as my father-in-law, who owned a chain of Dunkin' Donuts, used to say, the most dangerous words in the English language is open to the public. And by being a chiropractor, you guys are open to the public. And unfortunately, this gets into situations not only with regard to claims of malpractice, but also with the board. And usually it's the questions with regard to what decisions were made, what was the clinical judgment that was used, and what the result was. And these are the issues that you see over and over again, whether it's a licensing situation or whether it's a malpractice claim.
So can you give some examples of some of the most common, complaints that are filed against chiropractors that you've seen?
Yeah, with regard to malpractice, like I said, the one that is the most, fearful, of course, is a dissection. And of course, there's all types of literature out there with regard to whether or not there's an association or a connection between a chiropractic adjustment and a vertebral artery dissection. And their carotid arteries can be involved as well, but usually it's a vertebral artery. And the question is, what role does a chiropractic adjustment play in that? From my experience personally, I do not believe that a chiropractic adjustment can actually cause a vertebral dissection. The forces just aren't significant enough and applied in a way whereby it causes an artery to dissect. However, if there is a dissection that is underway or about to occur, a chiropractic adjustment can help it along. And that's the reason why, being aware of your patient's presentation and what complaints they are making before providing an adjustment, you have to be aware of those to determine whether or not an adjustment is appropriate. So, of course, that is the biggest one because, of course, the result can be devastating depending on, how the stroke develops. Sure. That's the biggest thing. You see compression fractures, elderly patients, they're susceptible to compression fractures with simple movement. And if indeed a compression fracture manifests itself after an adjustment, of course, they're going to claim that the chiropractor caused the compression fracture. And then, of course, it's the traditional disc type of injury. Usually the patient's vertebrae are in such a state whereby there's significant degeneration. If indeed you adjust, the disc problem can become more significant. So these are the type of things that you see over and over with regard to claims that are made.
So, and obviously these are some of the most horrific ones. The vertebral artery dissection, being one of the worst. What are some of the concrete steps that the practitioner can take to help to avoid these? And then minimize what am I trying to say? Minimize the negative outcome if something bad has occurred.
I wish I could tell you there's a magic potion that I could tell you about to avoid anything like this to either your patient or the fact that you could get sued for it. But it's really what you've always been taught. It's nothing that's really earth-shattering. But the biggest thing is taking a complete history and providing a complete evaluation and recording what it's about. That way you can avoid any allegation that you failed to consider a risk factor. Mm-hmm. The more you record, the better off you are. And it also it cements the fact that you are looking for it. And, it's good practice because it makes you think about it as you're going. Record it. Record what is known about the patient's condition when they come in, and also record what you're considering with regard to the care before you actually provide the care. Put down your thought process because of the fact that if indeed you do so, you're explaining the reason why you think the care will help the patient and why you think the care is appropriate. And if indeed that's in the record, essentially you can defend your clinical judgment. It's not something that is being created after the fact. It's actually in your record, and it shows that you are thinking about what you're being presented with and why you think the care that you're providing will be good for the patient and is clinically indicated.
So that's fascinating because I've never heard that before, and it makes such simple sense. And I always like to make things as easy as possible for the practitioner. So in today's world, most practitioners use some sort of EHR, electronic health record. And most of them, you can program in certain sentences so that it goes together and it ends up in the record. So it would be possible, and I'm thinking out loud, so I'm hoping you'll comment on it. It would be possible to come up with, I don't know, 3, 4, a half dozen different. I've considered A, B, and C as possible diagnoses, but based on my examination and history taken of the patient, this is the most logical differential diagnosis, and therefore this is the care that I will recommend. Does something like that make sense?
It would be extremely helpful to explain the situation to a trier of fact, namely the jury, to show how you got from point A to point B. It shows the thought process that got you there, and it shows that you did indeed consider the patient's condition, whether there are risk factors or not, and then you decided why you think the care is appropriate. If indeed, so many times you just see, a basic history, and then you provide the care, and the care is usually recorded. But there's nothing that tells why you went from one to the other. And, something like that would be extremely helpful, both for the attorney that's defending the case, but it also helps explain the situation to the attorney that's looking at the case to decide whether or not they take the case and make your life miserable for the next 2 years.
Right. And if it's something as simple as, writing a half dozen macros that you can click on as you're creating that initial note, it seems like a step that would be well worth taking.
I'm speaking from a lawyer's point of view. I know that quite often, you're reacting to things on the fly. A patient comes in, explains something to you, and it might be something out of the ordinary that's not in there. And you're reacting to it and providing the care to help the patient. I get that. But if you can do that in-between step, I think it will serve the chiropractor quite well. I really do.
I got to tell you, I have a lot more questions to ask and a lot more information I want to cover. But to me, that is the gold of this podcast interview. That is such a simple thing that would make every chiropractor's life so much easier if, God forbid, a case did arise. You're writing a couple macros, click on it, it's in your note, done.
It would help. It really does.
Wow. All right. So I want to switch gears ever so slightly. So, again, you and I have actually known each other for years and years in front of the board and et cetera. And I know you've taught seminars to our profession, for our profession, over a lot of years. You've taught for NCMIC at different events, and I assume you also attend conferences that are within your professional purview. I'm curious. So, from seminars that you have attended and or taught, what are some of the most outlandish cases that you have heard of, or perhaps even represented yourself, both egregious and like, you're kidding, this actually became a case? I'd love to hear both the extremes.
Yeah, and both, unfortunately, they were dissection cases, because they're the significant cases that you remember, because of the fact that obviously there's so much at stake, and for both the patient who's bringing the case and for the chiropractor, because of the fact that the damages are bad. But both of them were disc cases, one of which whereby the patient received an adjustment, had an immediate response with regard to dizziness, balance issue, visual disturbance, and the chiropractor had him just lay on the table. And I'm taking the deposition of the plaintiff, the patient, and the patient describes being left in the room, laying on the table, with the room spinning, and then described that the lights suddenly went out throughout the whole practice. And then about 30 or 40 minutes later, the lights came back on. The chiropractor came in and asked him if he wanted him to call his wife, and he called his wife, and the wife came and took him home. And then he started vomiting when he got home, and his wife took him to the hospital, and of course, we're off and running.
Mm-hmm.
So I asked the chiropractor about the lights going on and off, and he said, well, yeah, when we go to lunch, there's only one light switch that governs the whole office. So when we went to lunch, we must have turned off the lights.
Oh, you're kidding.
You guys went to lunch and left this guy laying on the table? And yep, they did. That was a case that had to be resolved, as you can well imagine.
Wow.
So, that also leads to, one of the other things that I point out in a lot of these seminars, that don't try to do too much. Or, when you recognize that there's a problem, don't think it's going to go away, or don't think that you can correct it. If indeed it's a problem, refer the patient.
Mm-hmm.
If it's something like this, something like, a possible stroke occurring, call 911. Be too cautious as opposed to not cautious enough. Get the patient out. Same way, if the patient's not improving with your care, don't be shy about referring him out to an orthopedist or a neurologist or a neurosurgeon. The longer you keep a patient when things are not going well, the less likely the patient's going to be happy with you. But more importantly, the greater the chance that the problem's going to get worse and worse and get out of control and put you in the middle of it. So don't try to do too much. When you see a problem, refer the patient out. That's something that a lot of chiropractors have great confidence in their abilities to correct a situation, and for the most part they're right. But at the same time, it can be a detriment too if you keep the patient in too long. So go ahead. I'm sorry.
Oh, no. So, one of the things that I've talked about on previous episodes of the podcast is, if for some reason a patient is not progressing as fast as you would like or expect, and patients get better on their schedule, not on ours, unfortunately.
Right.
But if they're not progressing the way that I expect, what I'll say to a patient, and what I've recommended previously, is, I'll say to the patient, we're going to get an opinion from an orthopedist. I don't think you need surgery. But you know what? I at least want to get an orthopedist opinion to make sure we're all on the same page. So we're going to bring other healthcare specialists onto the team. We're not necessarily saying, I'm done with you, I can't help you, goodbye, if I still think I can be of help. We're saying we're going to get whoever we need on the team. If it's an orthopedist, fine. If it's a neurologist, fine. If it's a physical therapist, fine. If it's an acupuncturist, fine. Whoever it may be, you know what? I'm your doctor. I'm going to make sure we have everybody on the team to get you the health that you need and deserve.
That's the perfect way to do it. And, it shows that you are considering other avenues of recovery. And, again, it all feeds into developing your clinical judgment. And it gives you more credibility with your patients when you do it the way you just described. It really does.
Yeah, even if it's something as simple as, maybe we're going to need an MRI. Well, in this day and age, third-party payers don't want to typically pay for an MRI until you have tried conservative care for a period of time. It's 2 to 4 weeks, depending on the third-party payer. Okay, so you can tell the person, I believe this is what you need, and this is the care we're going to provide. Terrific. But you know what? If 2 weeks from now we're having the same conversation, then we're going to order an MRI to make sure we're not missing anything.
That makes perfect sense to me, and I think it would make perfect sense along the way to both your patient and to anybody looking at the possibility of claiming malpractice.
Right. So you put that in the note. This is what I'm thinking. So, yeah, and thank you. I haven't mentioned that in quite a while, so I'm glad we have opportunity to discuss that again. So talking about some of the things, and you mentioned that one cervical dissection.
The other case is from the other perspective.
Go ahead.
How ridiculous it can be. I had another dissection case whereby it was apparent that the dissection occurred 9 days after the most recent chiropractic adjustment.
Really?
Yes, 9 days. But there was a well-known neurologist from Washington, D.C., who testified that the chiropractic adjustment 9 days earlier was the cause of the vertebral dissection that occurred 9 days after the care.
Oh, you're kidding.
And I cross-examined him with his own literature, his own research paper that indicated that in almost every case of vertebral dissections, there was pain that was prevalent at the time of the dissection. And of course, this individual, the patient, did not have any pain until 9 days after the adjustment. So essentially, I'm crossing the expert with his own paperwork, his own literature, his own research, because of the fact that his testimony was contrary to his own research. It was absurd. And, luckily we prevailed, but it was a week-long trial after 2 years of litigation. And, it was a painful experience for that chiropractor to go through.
Oh, I'm sure.
But because of the fact that somebody with authority, was convinced that, chiropractic adjustment was the cause. And, you do find that in the medical community. It's a little less every year. More, chiropractic becomes more and more accepted in the more traditional medicine. But at the same time, there are still those that are out there that are convinced that chiropractic adjustments, if it occurs anytime within a year or so, it can be the cause. So anyway, that's what we have to deal with from the defense point of view.
Unbelievable. So I want to switch gears because sadly time is starting to get away from us. So, again, with your years of experience, how and when does a doctor need to get representation, legal representation?
Well, a lot of it is a gut, because if indeed you have a patient who's expressing dissatisfaction and it is an outcome that is less than what you think is satisfactory, the safe thing to do is to call your malpractice carrier and put them on notice of the situation. It's not going to affect your premiums if indeed nothing comes out of it, but they will open up a file and you'll have a sounding board. And they may even assign an attorney for you to talk to about the situation so that you can prepare yourself with regard to when that request for records comes in, to essentially advise you with regard to how you interact with that patient if indeed the patient calls again. Obviously, the first thing you're going to be told is, don't go back and change the records. Even if indeed there's something missing that you want to put in, do not change the records. If you feel like you need to put an addendum in, put an addendum in, but make sure it's clear that it's an addendum. There's nothing worse than being exposed as changing records. That will shoot down any defense from, as soon as it's discovered. And most times it is discovered.
Yeah.
So, but that's the thing. It's a gut type of impression. If indeed the patient expressing dissatisfaction, and the outcome is less than ideal, be safe. Call your carrier. Consult with somebody, because of the fact that it's lonely out there when you got a patient that's upset with you and raising issues.
Sure. So I wanted to ask you, but I think you may have just answered it. So if a doc finds themselves in need of representation, how do they go about finding a really sharp attorney?
Well, usually the malpractice carriers and the chiropractic malpractice carriers have a list of great attorneys. So whichever state you're in, they will have a group of attorneys that will be on call for them to call upon to assist you. So that's probably the first place to go. In addition, if you need an attorney for, a contract matter or a lease or a license situation, usually they can give you advice on that too, or one of their attorneys will know somebody that has the specialty that you're looking for. So that's a good resource, to calling your malpractice carrier, because of the fact that, especially a company like NCMIC that pretty much exclusively insures chiropractors, they have attorneys that know issues that are relevant to chiropractors.
Yeah, I hadn't even thought of it. That's a fabulous resource. So I was going to ask you, and I still will. I'm curious. Have you represented people outside of the state of Maryland? Oh, and if not, would you, or could you even?
Well, you're only allowed to practice where you have a license. However, because of the fact that I've been around a while, good or bad, NCMIC, when they have a problematic case in one of the surrounding states, Delaware, New Jersey, Virginia, they have called on me to, they call it pro hoc vitae in, which is a Latin term with regard to becoming licensed temporarily in the state where the case is pending. And we have a local attorney that is involved in the case from whichever state it is, and then I come in and I can help out with regard to taking depositions and trying the case if it needs to go to trial. So, yes, I have done cases for NCMIC outside of the state, but I could not do it alone. I have to get an attorney in that state to recommend me and to bring me in on the pro hoc vitae basis.
So, having said that, if someone felt they needed to speak to you specifically, would you be outside of the state of Maryland? Would you be willing to take time to speak with them, or they should go straight to NCMIC and go through that avenue?
I'd be more than willing to talk with them, but more likely than not, if there's a specific issue that is case-centric, I would refer them to the attorneys that NCMIC have for that particular state. But, general things, sure. I mean, I like I said, many of the issues that are chiropractic in nature, I've seen before. So, I can talk people through that, but with regard to specific situations with regard to how a particular court will handle something, you should go, like Tip O'Neill used to say, all politics is local. Same thing with legal issues. You got to get to the local guys that know the lay of the land.
So what would be a way that somebody could contact you if they felt they needed to reach out?
Well, it's the easiest thing to do is to think of Hyatt as in the hotels, Weber as in the grills. No relation, unfortunately. You Google those two names together, and our firm website's going to come up, and you'll be able to get all my contact information as opposed to giving you email addresses or phone numbers. That's the best way to find me.
Fabulous. Paul, I can't thank you enough. It has been such a pleasure to spend this time with you. Hearing this information has been absolutely fabulous. And as I said, I can't thank you enough for taking the time, sharing your knowledge as you have today, because I know how incredibly busy your schedule is. You and I were trying to record this a couple of weeks ago, and I know you were in the middle of a big case that you said thankfully did turn out well. But thank you so much for taking and making the time to do this with me today.
Robert, always a pleasure to talk with you. And like I said, I'm very loyal to the chiropractic community. You guys got me got my start, to be perfectly honest.
Well, and I know on behalf of many chiropractors, at least here in the state of Maryland, we thank you for representing us over all these years. So Paul, thank you so much, and I'm sure we'll chat soon.
Pleasure. Take care.
All right. Bye-bye.
Bye.
All right. And that's our show for today. If you have a question about today's show or your own practice, feel free to reach out at theloveofchiropractic.com. Before making changes to your practice, be sure to seek legal advice regarding those changes and regulations in your state. For the Love of Chiropractic is an RGF production, all rights reserved. And thanks for listening. Original music provided by Hunter Rich Music.